You slip and fall on snow and ice here in the state of New York, and you want to know, is there ever an instance where an injured victim slips and falls on snow and ice and is found to be 100% responsible for causing their own accident? Would you like to learn about this? Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York personal injury and accident attorney, and now I'm shooting this video in the middle of winter in 2014. We're having an incredible cold streak, and we're having a lot of ice and snow. And it's a perfect opportunity for me to share this great information with you. So now, you slip and fall on snow or ice, you suffer a significant injury. Maybe you break your leg, maybe you break your arm, or even worse. And now you want to know, wait a second, should I have been more careful? Is there something I did that may have caused or contributed to my own accident? And importantly, has there ever been a case where a jury has come back and said that I'm 100% responsible for falling and causing my own injuries? And the tragic answer is yes, there have been instances like that. For example, let's say you've walked across this particular area where you now fell every single day, and you know that this is a dangerous and hazardous condition, and yet you never bothered to tell the property owner about this particular dangerous condition. And now you're wearing shoes that clearly are not meant for snow and ice. You're carrying bags, you're in a rush to do something, and now you're racing to get to the bus, you're racing to go to the car, and now you slip and fall. And you weren't paying attention. Maybe, in that instance, you may be responsible for causing your own accident. And now if you bring a lawsuit against the property owner, he turns around and said, nobody ever told me that there was a dangerous condition there. Nobody ever told me there was ice there. Nobody told me that there was something there that should have been cleaned away or taken care of. How am I supposed to know? Well, the argument is that you should have known. And now if a jury ultimately determines that you caused or contributed to your own injuries, there's a good chance that the jury will find that you are significantly at fault and responsible for your own injuries. They may ultimately find that the property owner is partially responsible. But now again, you being partially responsible, the property owner is partially responsible, and whatever compensation the jury gives to you for your harms and the losses that you have suffered will now be offset by the percentage of responsibility that you caused your own accident. Let's say, for example, the jury compensates you $1 million for the pain and the suffering you endured, but they find that you are 50% at fault for your own accident. That means that the most you could ever recover would be $500,000. That would be half of the $1 million. So why do I share this quick tidbit of information with you? I share it with you just to give you an insight and an understanding into how these types of accident cases work here in the state of New York. You know, I realize you're watching this because you have questions or concerns about your own particular accident. Well, if your accident happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.